Good afternoon. It is 3:03 p.m. on May 13th, and today's proceedings before the Board of Disciplinary Appeals are called to order. In furtherance of the Supreme Court of Texas's orders regarding remote proceedings, a three-member panel of the Board of Disciplinary Appeals will hear today's case through remote connection. If you get disconnected, please know that all proceedings will be paused until you regain a connection. If you've got any technical difficulties, we'll post the telephone number in the chat. I'll begin by introducing the panel. I am your chair, David Gonzalez from Austin. With us is Nancy Stone from Amarillo, as well as Cindy Tisdale from Granbury. The board has instructed parties and counsel to submit electronic files of any potential exhibits in advance. All exhibits still must be offered into evidence and admitted by the chair in order to be considered and made part of the record. If you wish to offer an exhibit in advance that wasn't submitted previously, please request leave to do so, and we'll allow that authorization through the screen share to indicate what's been admitted. There is a court reporter present, but there's a slight delay related to her seeing our lips move or not move. And so I'm just going to bear with your indulgence and ask that we give a second or two in between speaking to make sure that she's able to transcribe the proceedings. Likewise, the proceedings are recorded for the website. Any other recording is prohibited. At this time, I'll call cause number 64480 in the matter of Paul Houston Lavelle. Counsel, would you please make your appearances for the record?
Judith DeBerry for the Commission for Lawyer Discipline. Can you not hear
You're
me?
on mute. We heard you.
I can hear you, Mr. Berry. I think Mr. Lavalle was speaking, but we couldn't hear him because he was on mute.
Okay.
Yeah. Sir, go ahead.
Mr. Chair, this is Paul Houston Lavelle, the respondent herein.
This is a compulsory discipline hearing under Rule 804 of the Texas Rules of Disciplinary Procedure. When an attorney has been convicted of an intentional crime or placed on probation for an intentional crime, he shall be suspended as an attorney licensed to practice law in Texas during the appeal of that conviction. Earlier today, we rendered or issued a written order regarding respondents' objection to remote proceedings, as well as an order denying a plea in abatement. I have before me both a notice of removal that was filed on May 12th, 2020 by Mr. Lavalle, and a response to the notice of removal filed today. Mr. Berry, the board had reviewed your filing and appreciate the clarity and the guidance related to the notice of removal. And so at this point, Mr. Lavalle, I would ask, I'm actually going to turn it over to you. There's four different arguments that were made in response to the notice of removal. And I'd like to begin with your arguments in response to first, the matter of subject matter jurisdiction. The petitioner is arguing that the federal court does not have subject matter jurisdiction to hear state disciplinary cases. What is your position on that matter?
Sir, regarding the removal, I choose to stand on the pleadings on file.
Okay. And so would you like me to inquire as to the responses to the other three arguments made in the response to your notice of removal, or just assume that you will have the same answer for all of those other three subjects?
The answer would be the same for all four, Mr. Chair.
Okay. Mr. Berry, do you have any response? Anything you also want to say regarding your response to the notice of removal?
Well, I would stand on my pleading. If you would like a summation of the arguments, I can give those to you very briefly for the record.
You may.
Okay. First of all, this is an administrative proceeding. It is not in a court of law, so I could find no authority that would allow an administrative action to be transferred or removed to federal court. That's number one. And I'll do these briefly. Number two, although he calls it a notice of removal, the pleading he actually filed is not a removal of the suit against him, but a separate cause of action against Shauna Willing, who's chief disciplinary counsel. So totally different case. And He also requested a stay or injunction or temporary restraining order, but there is no, the court has not issued an order on that request. Number 3, it's procedurally defective. He had 30 days under the federal rules to file a removal, even if he could, even if it was a removal, which we don't concede that it is. He didn't do that within the time limit, so it's facially defective because he waited 57 days to file what he calls a removal that's actually a new suit. 4th is the jurisdictional issue, and I think the case of Musselwhite versus the State Bar of Texas clearly sets out, and that's a Fifth Circuit case, that the federal courts don't have jurisdiction to hear disciplinary matters. That's our arguments in a nutshell. And so I would respectfully request that this board find that retain jurisdiction over this case and proceed with the hearing today. Thank you.
Mr. Lavalle, any response?
Respondent objects generally.
May I inquire if there's anything with particular concern about the due process proceedings that are either raised in your federal suit or in your objections here?
Mr. Chair, I believe all of my pleadings speak for themselves.
Okay. So nothing further that you wish to address regarding the notice of removal, sir?
Not in this forum, sir.
Okay. Anything else, Ms. DeBerry?
Now, I would just say that I think the due process requirements are met. There are procedures that were written that were given with the notice of this hearing, and all that's required for due process is notice and an opportunity to be heard. And I think Mr. Lavalle has been given those due process requirements.
Thank you very much. Counsel, because we're a panel, what I'd like to do at this time is go off the record so I can confer with Ms. Stone and Ms. Tisdale related to the matter. We'll be in recess. Ms. Truitt, if you can please place the parties in the waiting room. We are just waiting for Ms. There we go, Ms. Seibert. Ms. Seibert, you ready? Great. We're back on the record in cause number 64480 in the matter of Paul Houston Lavalle. At this point, the petitioner may proceed.
Thank you. May it please the board. This is a compulsory disciplinary case based on respondent's conviction for tampering, fabricating physical evidence, a third-degree felony in violation of the Texas Penal Code 37.09C in the 56th District Court of Galveston County. The petition for compulsory discipline was filed with the board on June the 10th, 2020. The first amended petition for compulsory discipline was filed with the board on September the 9th, 2020. The second amended petition for compulsory discipline was filed on March the 10th, 2021, and respondent was personally served on March the 16th, 2021, with the second amended petition for compulsory discipline and notice of the hearing by Patrick M. Larkin, a Galveston County Deputy Constable. The original proof of service was filed with the board on March the 19th, 2021. On March the 21st, 2019, the respondent was charged by indictment with count 1, which states, on or about October the 14th, 2018, knowing that an investigation was in progress, namely furnishing alcohol to a minor, intentionally and knowingly make and or present a document, namely the affidavit of Sarah Carlin, with the knowledge of its falsity and with intent to affect the course or outcome of the furnishing of alcohol to a minor investigation. And count 2, which reads basically the same, except it was the affidavit of a Jailene, Jailene Solis, Soliz. The affidavits were submitted in cause number 19 CR 0918, styled the State of Texas versus Paul Houston Lavalle in the 56th Judicial District Court of Galveston County, Texas. On February the 28th, 2020, a judgment of conviction by jury was entered in the same cause. wherein the respondent was found guilty of tampering, fabricating physical evidence, and was sentenced to 5 years in the Institutional Division of the Texas Department of Criminal Justice. The sentence of confinement was suspended and respondent was placed on community supervision for 5 years in order to pay court costs in the amount of $290 and reimbursement in the amount of $87. At this time, I would offer the following exhibits. Exhibit number 1, which is a certified copy of the indictment in the underlying criminal case. Exhibit number 2 is a certified copy of the judgment of conviction by jury entered in the underlying criminal case. Exhibit 3 is my original affidavit as the attorney of record for the petitioner, attesting to the fact that the respondent is the same person as the person identified in the underlying criminal case. Exhibit 4 is the original certificate of Blake A. Hawthorne, clerk of the Supreme Court of Texas, dated April the 6th, 2021, which indicates that respondent is licensed and currently authorized to practice law in the state of Texas. And exhibit number 5 is a certified copy of respondent's prior disciplinary judgments. Those are 3 private reprimands. On February the 28th, 2020, I would offer those at this time.
Any objections?
Sir, I'm going to need just a moment with the exhibits. I cannot seem to locate my electronic copy at this time.
Yes, sir.
I'm going to set the phone down for just a moment. Mr. Chair, my apologies, but I'm unable to locate the exhibits. Could I just get the list of exhibits in numerical order, please?
You want me to repeat those?
Yes, ma'am, if you would be so kind.
Number one was a certified copy of the indictment in your criminal case.
Yes, ma'am.
Number 2 was a certified copy of the judgment of conviction by jury.
Yes, ma'am.
Number 3 was my affidavit attesting the fact that you're the same person that's named in the criminal indictment and judgment of conviction. Number 4 was a certificate from Blake A. Hawthorne stating that you are licensed and currently authorized to practice law in the state of Texas. And Exhibit 5 were copies of 3 prior private reprimand disciplinary judgments against you. Do you want the dates of those judgments?
Mr. Chair, may I do my responses out of order?
Certainly, go ahead.
I have no objection to 2, no objection to 4. As to 1, I do have an objection in that it's my belief, I don't have it in front of me, but it's my belief that the indictment that's being offered into evidence was the first indictment and not the later superseding indictment. So that's the objection as to 1. As to 3, I need to take the witness on a brief voir dire, if I may.
Okay, well, let's go through your last objection. And your objection to
Yes,
5?
As to 5, I'm really not trying to delay the proceedings here, Mr. Chair, but I really need to get a look at those. Is it possible they could be emailed to me just so I could take a brief view of them?
Well, we can see if they can be screen shared,
That's fine.
or at that point, I don't know if Mr. Berry has them up, but let me first, for the record, go ahead.
I do not. I can give you the dates.
Have you had a chance? You've received, one second, Mr. Law, you've received a copy of them before. But you
I
just don't
thought-
have them again.
Yes, sir. I thought I had received it electronically, but I cannot find it anywhere in my email.
Okay.
Would you happen to have the date that it went out, and maybe I could just reference it by date?
Well, let me start. Let me do two things first.
Yes, sir.
Exhibit number 2 is admitted, which is a copy of the judgment of conviction.
Yes, sir.
Exhibit number 4 is admitted, which is the certificate from Blake A. Hawthorne.
Yes, sir.
Regarding your objection to number 1, that it's not the same indictment, or that it's the first indictment and not the superseding indictment, let me ask you a couple of questions related to your objection.
Yes, sir.
Is there any question as to whether or not you are the same person that was charged by indictment with tampering or fabricating with physical evidence, had a trial by jury, was convicted, and your case is currently on appeal?
I can confirm that I do have a case on appeal, sir.
So tell me your objection. What is the difference? Does the superseding indictment charge you with a different crime than the indictment that you say may be different in exhibit number 1?
It would, from memory, it's my belief it's the same charge. I just cannot recall, as I stand here today, which indictment the district attorney and the jury proceeded and deliberated on.
I understand. So for purposes of your objection, there's no dispute that exhibit number 1, as you recall, is a fair and accurate copy of one indictment, but your question is whether it's the same indictment that you went to trial on.
Yes, sir. I will stipulate that it should be a fair and accurate replica of one of the indictments in the file.
All right. Now, as to your request, so let me hold off on that 1 second. As
Yes,
to your
sir.
request to take the witness on voir dire regarding exhibit number 3,
Yes, sir.
please help me understand the purpose of that, if this is a question about whether or not you're the same person that was convicted in that cause number. If exhibit number 2 is admitted related to the judgment, help me understand why you would need to take the witness on voir dire.
This witness saw fit to file a sworn document in a formal proceeding. And it's this witness that claims to identify me as the person that is one and the same. I just want to find out what the basis was, or at the formulation, or where the information and belief came from, because the document in itself doesn't explain it. This is certainly not somebody that knows me personally, that's acquainted with me, etc. And I would just like, for the purposes of the record in this matter, to develop how Mr. Berry came to that conclusion.
I'm going to overrule your request to take the witness on voir dire, and I will overrule your objection to exhibit number 3, and exhibit number 3 is admitted. As to your objection to exhibit number 1, I will admit exhibit number 1 over your objection. I will make a notation, or at least will note your objection for the record, that there may be a difference in language between a superseding indictment, but that without your ability to compare exhibit number 1 to know if it's a superseding indictment, obviously we don't know if Exhibit 1 is the superseding indictment or the first indictment. But based upon Exhibit number 2 and based upon the filings that you referred to as part of your suit that you filed a notice of yesterday, it appears that substantially the elements of the offense of tampering or fabricating with physical evidence that appear in Exhibit number 1 substantiate the jury's finding in Exhibit number 2 and are further bolstered by your filings in federal court, which also relate to that case on appeal. And the only remaining matter we have is your objections or your request to see copies of Exhibit number 5. So have you had a chance to review Exhibit number 5 yet?
I cannot locate it in my electronic records. I certainly have not been handed a paper exhibit as the procedure policy seems to outline. So if anyone would be kind enough to show me one, I'll be prepared to move forward within moments.
You will give me a second. I will see if I can find that.
Actually, Mr. Bear, what I'm going to do is I'm going to sustain an objection to Exhibit number 5. Whether it's seen or not, given the scope of what the proceedings are under 804, I'm not convinced Exhibit number 5 is relevant to the issue as to whether or not it's an intentional crime. So Exhibit number 5 is not admitted.
Okay.
Thank you, Mr. Chair.
Mr. Gonzalez, when we, if there's an interlocutory order, when we come back for motion, if we come back for motion to enter, can we admit those at that time, because it would be relevant to whether he's suspended or disbarred?
I do think at that point, after the appeal is finished, my reading of 804 suggests that at that point it does become relevant under the Asazi factor application.
Okay.
I'm just not convinced at this juncture, based on the reading, that the board has any discretion other than to follow the text of Rule 804 based upon the conviction and probation.
Okay, that's fine.
So with those rulings on the exhibits having been made, Mr. Bear, you may proceed.
Okay. On February the 28th, 2020, the respondent filed a notice of appeal, appealing his criminal conviction to the 14th Court of Appeal. At this time, we respectfully request the entry of an interlocutory order of suspension pending the outcome of respondent's criminal matter. Thank you.
All right. Mr. Lavalle, you may proceed.
Just so I know where we're at, is the movement resting at this time?
Yes.
Sir, I'm going to make a very, very brief presentation or argument.
Go ahead, sir.
My concern since entering this process with this forum has to do with my substantial due process rights under the 14th Amendment to the United States Constitution, specifically a property right interest I would have in my livelihood and state license, as well as making sure that traditional notions of substantial fair play and due process are followed. I'm respectfully asking at this time that this panel find that the pleadings and proof in this matter are wholly defective, in that this is a matter that it appears the Chief Disciplinary Counsel's office has been working on for a number of years. Although I've recently only received notice of their third filing, they've had 3 shots at getting this filed and getting it correct. They presented some evidence today regarding a conviction on appeal in the 56th Judicial District Court, which is a general district, the Court of General District Court jurisdiction sitting in Galveston County, Texas. But the proof that's been presented does not match the pleadings that are active, live, and on file today. Specifically, at the CDC Second Amended Petition for Compulsory Discipline, at paragraph 4, it shows that a jury in the 57th District Court of Galveston County, Texas, found me guilty. The 57th District Court is a civil district court located in San Antonio, Bexar County, Texas. I'm not trying to nitpick here, but the CDC has a responsibility, and that responsibility is to get it right before they drag me down here. I'm asking at this time that you do not enter an interlocutory order and afford me the rights I'm entitled to. Thank you, Mr. Chair.
Yes, sir. So let me see if I understand. So if I look at paragraph 4, your argument is that it's the 57th Judicial District Court in Galveston that's based in their petition. But if we look at what's been admitted as exhibit number 2, it's the 56th Judicial District Court. Is that my understanding?
The 56th District Court has criminal jurisdiction and is located in Galveston, Texas. The 57th is a civil district court located in San Antonio, Bexar County, Texas, in which I've never appeared in any capacity whatsoever.
So if exhibit number 2 has a copy of the judgment, help me understand the harm in paragraph 4 if it lists the wrong court.
The harm, sir, would be in the notice and the opportunity to respond to the pleadings on file herein. If there were no pleadings on file herein, there would be no exhibits.
Okay.
I mean, I'm totally glossing over the fact that when I was served this, I got half of the procedures. Apparently, the CDC uses duplex printing, and so they were kind enough to send me the first page of the table of contents, the odd numbered pages, and what do you know? The second page of the table of contents and page 8 has the compulsory disciplinary procedures, none of which I could find anything relating to doing remote hearings on, because it talked about bringing additional copies of exhibits to the in-person proceeding.
Okay.
That's my position on everything, and I'm ready for this body to do whatever it feels it needs to do. Thank you.
Yes, sir. Mr. Berry, do you have any response or rebuttal?
Well, I think I'll address his comments about bringing exhibits to an in-person hearing. I believe the directions that were served with the notice of hearing and that it would be remote included directions on how to give all the parties notice of any exhibits you wanted to have admitted. If there's a typographical error in the petition, I would find it harmless, because attached to that petition were copies of the judgment that clearly indicate that it was in the 56th District Court. Regarding his comments about trying to get him served, Mr. Lavalle does not provide the State Bar with his residential address. The only one we had was in Kemah, Texas. Apparently he doesn't reside there, and we tried numerous times to get him served and were unable to. So whether he was avoiding service or whether
Mr. Chair, I'm going to object to
doesn't
all of that as
give
being
us-
wholly outside of the record of this matter.
To the extent that you mentioned service, for purposes of this hearing, I'll sustain your objection.
Thank you, sir.
You may proceed, counsel.
and the only reason I mentioned that was because he brought it up.
Okay, go ahead.
That's
Go
all. I respectfully request an entry of judgment of interlocutory judgment of suspension.
Pursuant to Rule 804, the statute of the Texas Rules of Disciplinary Procedure state that upon introduction into evidence of a certified copy of a judgment of conviction and a certificate from the clerk of the Supreme Court that an attorney is licensed, the Board of Disciplinary Appeals shall immediately determine whether the attorney has been convicted of an intentional crime or granted probation for an intentional crime. So the final matter that I'll ask Mr. Lavalle is, do you have any argument or evidence related to whether or not tampering or fabricating with evidence is an intentional crime?
Under the statute, sir, it appears to be an intentional crime. Under the facts as applied in the underlying instant case, it can't even get close to that.
Mr. Berry, what is the commission's position on whether or not this is an intentional crime?
It is an intentional crime. The board goes by the elements of the crime, not the facts underneath the crime, to determine whether a crime is an intentional crime or not. So under that standard, and Mr. Lavalle has said the statute, I'm sorry, my phone's going off in the office. It hadn't rung for months. It is an intentional crime because we don't look at the facts underneath. We just look at the elements of the crime.
Ms. Stone, Ms. Tisdale, do you have any questions for either of the parties?
I don't at this time. Thank you.
Ms. Stone?
I'm sorry. No, I don't at this time. Thank you.
Counsel, anything further at that point before the board adjourns?
Not if you all have no questions, no, the commission does not have anything further.
Mr. Lavalle, anything further?
Nothing from the respondent, Mr. Chair. Thank you.
Okay. Counsel, thank you very much. The board will take the case under advisement. This concludes today's proceedings before the Board of Disciplinary Appeals. We are adjourned.
Thank
May I
you.
be excused?
You may.
Thank you, Mr. Chair.